Being here today with you, students, reminds me of my days as a law student back home in the Gambia. During my teenage years, I worked for some time as a clerk at a local court. And I saw, in particular, many women appear before the court being the victim of rape and sexual and domestic violence. And most of these women were represented by male lawyers. Not that I have anything against male lawyers. Also, most of the judges were men, and I remember thinking to myself, what can I do to change this? Because I want to change this. There is something, I said to myself, there is something I can do. There is something I can do to change the way the justice system is addressing the plight of these women. So I decided to study law first, and to be able to contribute in whatever way I could to assist these victims. And I was inspired by my professors and by the reality that I saw around me. I wanted to see if something could be done to remedy that situation, to bring justice to these women, to redress what has been done to them, to change through the implementation of the rule of law, the behaviors of those who were capable of committing such crimes. I believed then, as I believe now, in the power of the law as a potent tool to stop and prevent violence, to pacify communities. And that belief that I had then, that belief in change, has never left me. And as I speak to you today, I recognize in your eyes that bond we all share when we are sitting in universities, when this hunger that we all have for change, this hope for a better world, a more peaceful, a more just world. Today, I would like to discuss with you how the work of the International Criminal Court can contribute to this change. And I would like to introduce the idea of a new paradigm in international relations, which was introduced by the drafters of the Rome Statute and the establishment of the International Criminal Court. This idea is that law is a global tool to contribute to world peace and security. In a time of rapid globalization, the world has increasingly become a smaller place. New technologies allow us to reach each other in previously remote places in the world. Political, military, and economic interests are more and more complex. And wars and conflicts are no longer the opposition of two states or two armies. They involve various groups, states and non-state actors, and have huge ripple effects, from destabilizing entire regions to impacting on the international financial markets. And in short, we are no longer confined to our town or to our region or our national borders. What happens in Darfur, in Sudan, or what happens in northern Uganda has an impact in our lives. I am a fervent believer in the preventive and normative power of the rule of law. I believe that law is the ultimate weapon that we have to protect the weak and the oppressed against the strong. The International Criminal Court has a critical role to play in this regard, in particular in helping victims and also in helping to prevent massive crimes. In order to realize the full potential of the court in terms of protection, however, we have to maximize its preventive impact around the globe. The answers to the questions of how to stop the genocide in Darfur, how to prevent a new cycle of violence in Kenya, lie with the preventive impact of the court. Application of one standard to all member states is crucial. It is crucial in maintaining the credibility and the effectiveness of the court. It has been an utmost priority for the Office of the Prosecutor to be guided by evidence and by evidence only, without being influenced by any political consideration while choosing situations to open an investigation. However, this is unfortunately not the story that is relayed in the media. Again and again, we hear criticisms about our so-called focus on Africa, about the court being an African court. It's when I hear the criticism about this so-called Africa bias, how quick we are to focus on the words and propaganda of a few powerful, influential individuals, and to forget about the millions of anonymous people, the victims, who suffer from these crimes. Indeed, the greatest affront to victims of these brutal, unimaginable crimes, women and young girls raped, families brutalized, robbed of everything, entire communities terrorized and shattered, is to see these powerful individuals responsible for their sufferings by trying to portray themselves as victims of a pro-Western, anti-African court. Justice, real justice, is not a pick and choose system. To be effective, to be just, and to have a lasting impact, justice has to be guided solely by the law and by the evidence. And my focus is on individual criminal behavior against innocent victims. My focus is on Joseph Kony, Bosco Ntaganda, Ahmed Haroun, Omar al-Bashir. The ICC cannot, however, succeed in this fight against impunity alone. The Rome Statute establishing the ICC sets up a framework for states to adhere to. State cooperation and national legal systems are of vital importance in the ICC regime, as the court does not have an enforcement mechanism at its disposal. ICC's success in the long run will thus depend on a combination of national and international efforts. If complemented with necessary cooperation from states, the ICC's preventive impact and potential contributions to conflict management and peace building are unprecedented. The so-called justice versus peace, this debate is yet another unfair criticism that the court has received in the past few years. And to my experience, peace and justice cannot be considered as negatively correlated concepts. On the contrary, interest of justice and interest of peace almost always intersect and are complementary parts of a larger process. Even though the Office of the Prosecutor of the ICC cannot adjust itself to political negotiations and mediation attempts, as it is, a prosecutorial arm of an independent and a permanent judicial system, the office still considers peace as an overarching objective for serving the interest of justice. Ladies and gentlemen, the ICC is a powerful new tool to control violence in the world, to deter crimes, to promote national proceedings. But it can only be successful if we never yield to political considerations. We are a new tool, we are a judicial tool, not in the tool of the hands of politicians who think they can decide to plug or unplug us. If we don't receive consistent support, strong support from actors that shape the international relations, such as political leaders, international and regional organizations, as well as civil society organizations, the court will not be able to fulfill its mandate. And the prospects of ending impunity and realization of international justice will become unlikely. And as we celebrate our 10-year anniversary, the Rome Statute is extending, building a network of actors around the world to maximize the prevention of massive crimes and enforce common standards. Step by step, the Rome Statute system is moving ahead, and it's creating a new international dynamic, impacting other institutions and changing international relations forever. The Rome Statute system is changing the balance of power between those few powerful individuals who thought they could get away with massive crimes and their victims.